Good morning. My name is Hamra Ahmed. I am the Director of Law and Policy at Her Justice. And I will introduce our panelists in just a moment. And as Jennifer stated earlier, their complete bios, which are very impressive, are on the WOVA website, on the app. So over the past several years, we have seen an increased attention about the devastating consequences of bias in the criminal justice system. And litigants, survivors, practitioners, and other stakeholders engaging in the civil justice system have also seen real life implications of bias in our civil courts. Judges Weber, Ellerin, and Kluger shared recent reports and efforts that identified biases in the court system, primarily along the lines of race, gender, and economic status. This conference is an opportunity to move towards raising awareness of the real life impacts, an opportunity to listen to litigant voices, and to engage in discussion towards increased transparency, collaboration, accountability, so that we can address this pervasive issue. In this panel, we are going to dig deeper into what bias looks like, how it functions, and the impact of bias on individuals and communities. Our panelists include survivor litigants, researcher, practitioners, who will speak from their unique lived experiences and expertise in this area. Our first panelist, Jacqueline Franchetti, is Executive Director and Kira's mom of Kira's Champion. Linda Lopez, a Deputy Director of the Legal Center at Sanctuary for Families. Dr. Carolyn Springer, Associate Professor and Director of the Gordon F. Derner School of Psychology and Director of African, Black, and Caribbean Studies at the College of Arts and Sciences at Adelphi University. And Shane Filcher, who is Executive Director of the LGBT Bar Association and Foundation of New York and Legal. So before we begin, I'd like to share just a trigger warning, as Jennifer had mentioned earlier this morning. Speakers at this conference will explore many topics related to domestic violence, including firsthand experiences with trauma and bias, which at times may be triggering. On WOVA, please review the community guidelines and self-care sections so this space remains a safe place to engage and learn. We urge you to prioritize your self-care, take breaks when needed, and don't be afraid to tune out or sign off or leave the room if you're feeling overwhelmed. So I'd like to start with Jacqueline. Would you please share your experience with the New York Family Court?
You know, as I start to look at my experience within New York State Family Court and really all courts across the United States, I look at this and recognize it from the standpoint of abusers versus safe parents, abusers versus protective parents, abusers versus non-offenders. My daughter, Kira, is one of 33 children to be murdered by their own mother or father while going through a custody case or a separation in New York State in the last 6 years alone. And that awful number doesn't take into account the number of children who are court-ordered into a home where they're being beaten, raped, or emotionally devastated each and every day. This is the epidemic that will outlast the current pandemic unless changes are made. The very first time that I walked into Nassau County Family Court, I thought I was on safe ground, and I wasn't, and no one is. When I walked into Nassau County the first time, and I told the judge that Kira's father, her murderer, was suicidal, abusive, threatening me and Kira, stalking us, that I was terrified. The judge yelled at me to quote unquote grow up. We had Child Protective Services involved in Kira's case. They noted that he had extreme anger and rage issues, an inability to care for her at a young age. And they labeled it no risk, and low domestic violence. Kira had an attorney, the attorney for the child, who knew of the abuse, dismissed it even 5 days before her murder. We had a forensic evaluator involved in Kira's case who saw documented evidence, heard from eyewitnesses of the abuse, knew that he had purchased not one, but 2 guns recently, amongst all the other things. And he advocated for joint custody in his report. And just days before Kira's murder, when we again went to court, the judge said, quote unquote, this is not a life or death situation. She was wrong. Days later, Kira was found with not one, but 2 bullets in her back. Hitchman, she had been shot twice. He had then poured gasoline all over his home, set it on fire, and he killed himself in a murder-suicide. If just one of those people involved in Kira's case had made her life, had made her safety a priority, Kira would be here today. But they didn't. And what happened to Kira can happen to someone you know and love unless changes are made. And we need to, and we started hearing this from panel just before us, we need to educate and we need to empower our courts. These cases, you know, when you look at them, there are mad cases, but far too many of them are dangerous cases. And the courts just lump them all into mad. We need to evaluate if they're dangerous, and if they're not dangerous, put them in the mad category, not the reverse. These are life and death situations. And the way that victims and survivors are treated in our court system absolutely must change.
Thank you, Jacqueline, for sharing your story. Linda, as an experienced litigator in New York City family courts, representing hundreds of survivors, what have you observed and experienced yourself?
First, I just want to say thank you so much for sharing your story with us. We know it must be really, really difficult for you to do so. We read your story all the time, but hearing it from you and seeing you is just, the impact is just profound. And I just want to say I'm eternally grateful to you for doing that. It's interesting that we're using the word bias to describe what really is racism, sexism, and misogyny in the courts. It's more than just unfairness. I recall when I was in law school at the Battered Women's Clinic, and my first court appearance was before a judge. And the judge called a sidebar with the attorneys and allowed all the students to speak. But when I spoke, she stopped me and told me that you use the term between when 2 people are speaking and the term among when 3 people are speaking. What was profound to me at the time was that I was so elated to be in court that I really didn't catch what had just happened. Until back at law school, I heard 3 of my white colleagues say that they could not believe that the judge stopped me to correct my grammar. And then it hit me. And I remember having that sinking feeling. And what we call now a microaggression was something that I didn't even recognize at the time. One of my first cases at Sanctuary was representing a client in family court in a custody case. She was a devoted mother of 2 children who had experienced severe physical violence by the father. Both were monolingual Spanish speaking, but he was employed and she was not. During many appearances, the judge routinely yelled at her. On her first day of trial, she testified about him grabbing her head and banging it repeatedly against the wall. to having severe headaches and to him denying her medical attention. When there was an objection and the client answered without the judge ruling, the judge yelled at her. She screamed at her repeatedly throughout the trial. When we returned on the adjourned date, the client told me she could no longer endure the judge's abuse and she wanted to relinquish custody. Nothing I said changed her mind. It was devastating and it still haunts me today. On another case, I appeared with my co-counsel, who is also Latina. We were trying to reunite our client, whose father was refusing to return the child after a visit. New York was not the home state of the child. The judge refused, and when we continued to advocate for our client, she threw a stapler at me. On another appearance, she kept the courtroom locked, and she told me, and the court officer told me, that I had to make any objections or applications to him, and he would relay it to the court and then report back to me. At yet another appearance, she threatened to hold me in contempt so many times that the court officer approached my co-counsel and asked her to get me to stop because he didn't want to arrest me. We developed the code DEFCON 3, which meant that if one of us was held in contempt, the other had to pick the kids up at school. On several appearances, she would call me by my co-counsel's name, despite us having very different names and me repeatedly putting my name on the record. Our client had to leave Florida without her son, and it would be 6 months before we were able to reunite her. During my 28 years of practice, I have witnessed male attorneys scream, interrupt the judge, make offensive and outlandish statements, miss appearances, or come unprepared. Never have I seen them treated the way the attorneys of color have been treated. Cultural differences in custody cases can have devastating consequences. During the direct examination of one of my clients, she testified to waking up in the middle of the night by the children's father strangling her, while their 3-year-old son was sleeping in the bed. As she sobbed, the judge stopped her and yelled at her that it was inappropriate for her son to sleep with her and that she had to stop it immediately. The look on her face was heart-wrenching. The judge awarded the father sole legal custody of both children. Judges do not realize that when their actions and comments, whether overtly or subconsciously, have racial, classist, or sexist underpinnings, it endangers the lives of the litigants and their attorneys by empowering abusers. Shortly before COVID, I was representing a client in Supreme Court on a contempt motion I filed. I had represented this client for over 3 years in family court and in Supreme Court. I filed a contempt motion. I highlighted the provisions in the court order stipulation that the husband failed to comply with, coupled with the documentation demonstrating noncompliance. The judge stopped me at one point and said, "Counselor, it sounds like you're taking this personally." I had no idea what he was talking about. It was a simple motion, a court order stipulation, documentation of noncompliance, 2 + 2 = 4. Nothing I said was about me. After we left apart, the abuser approached me and my client and began to verbally attack me. He yelled at me inches away from my face. To put it in context, I'm 5 feet and he's over 6 feet and a firefighter. My client was terrified. I asked him repeatedly to step away from me or I would have him arrested. I walked away and he followed me. No court officers were present. As I walked away with my client, he continued yelling and following me until I again threatened to have him arrested. He then walked away. I knocked repeatedly on the park door to see if I could find a court officer. Eventually, someone opened, told me there was nothing they could do, and closed the door. We waited for over an hour, afraid that he was waiting for us outside. The abuser had never spoken to me or approached me in the 3 years before that day. There is no doubt in my mind that his behavior that day was a direct result of the judge's comment during our appearance. Our clients experience a double standard as mothers. They need to be perfect, whereas fathers are expected to be imperfect and they are praised even when there is evidence of violence. They are told that they are hysterical, mentally unstable, master manipulators, and frauds. Practically every single immigrant client is accused of committing immigration fraud by raising allegations of domestic violence to obtain a green card when all they are really seeking is protection for themselves and their children. Many times our clients reconcile because they're afraid and refuse to continue being further abused by the court system. We will discuss possible solutions, but the biggest step is to acknowledge that racism, classism, and misogyny exists in our courts.
Thank you, Linda. Just wanted to pause and recognize how powerful these stories are and to acknowledge the empathy that I feel and I see in the faces of everyone here in the room, and I'm sure the people on Zoom that I can't see, and how important it is that these narratives are shared and discussed, and the courage and bravery it takes to share this. So thank you. Shane, you have fought for equality of all LGBTQIA community members as a practicing attorney and now as an executive director. Can you speak to how bias is affecting and impacting access to justice in that community?
Certainly, and I too want to echo my thanks for the opportunity to be here at the conference today and to my co-panelists for everything they've shared so far. So just to kind of take a step back from your question, the bias is truly built in before the community members are even setting one foot into the courtroom, right? We've all heard the question, why didn't your client call the police? Well, this room more than anyone else knows the usual set of answers to that, but I want to frame it in terms of the context of the LGBTQ+ community and remind everyone that this is a community that's been historically over-policed for decades, has little to no trust for the police, and continues to be over-policed. And even the presence of the NYPD at Pride parades is still a controversial topic. So to have that additional consideration in terms of why the client may not have felt safe or comfortable in approaching the police. And then let's say whether they approach the police or not, when they want to reach out to a provider for assistance, if the client is particularly transgender or non-binary, the services are clearly built around the needs of cisgender women, both in terms of the marketing on the advertisements on the website, even the names of the organization. So this person is left wondering, am I going to be misgendered if I reach out for help? So these are, low cost fixes that immediately exclude people from the system. So let's say the person has got past both of those barriers, that the police issue, finding access to services, now they're actually entering into the court system. The court systems were not designed for our families, right? Legal recognition of our families is very recent at best. And I want to—
Could you speak into the mic a little
Sure.
bit more? Make sure that, thank you.
So these systems, the court systems were not designed for our families, and everyone is aware of that. And I want to remind this room how recent, truly, recognition of our families are. Marriage, New York was a leader in marriage equality years before the groundbreaking Supreme Court decision, but New York has not always been at the forefront of family law protections for LGBTQ+ communities, particularly in terms of recognition of the rights of non-biological unmarried parents. That issue remains ongoing, frankly, in terms of litigation. So there are a number of issues systemically that are built in. And the first panel did such a wonderful job of introducing how that perhaps this area of law more than any other, credibility is king, right? And this is a community whose credibility has been attacked for decades. We've all heard the ugly things that have been leveraged against lesbian, gay, and bisexual people in the 80s and 90s. And now, unfortunately, many of those attacks are being rebranded and utilized against our transgender, non-binary, and gender non-conforming siblings. So there's still a long way to go in terms of litigants being trusted with their experience to be the experts on what their families are and to trust the systems will take care of them.
Absolutely, thank you. And just as a reminder to all the panelists to try and speak into the mic to make sure that we can hear all of your excellent remarks. So, social science research tells us that we form opinions early and then seek to reinforce that belief. So, you undervalue opposing data and you overvalue confirming data. Dr. Springer, as a researcher, you have examined bias in many systems, including the healthcare system. How can social science help us understand these experiences, and what does social science say about how to combat these issues?
Sure. I want to thank my panelists for sharing their experiences because it really touches close to the heart. One of the things I think when we try to understand situations, we have to remember we want to understand it not to excuse it, but to think about ways we can intervene. And social science is helpful in really trying to get us to understand why some of these things occur. We make mistakes all the time. We think about the fact that we're surrounded by lots of information. We have to process this information and we have to make judgments. Often we're making these judgments under duress. We have to make them quickly and so forth. But the problem is that when we do these kinds of things, we incur biases. And so one of the first things we need to understand is some of the biases we make when we process information. So for example, think about the fact that the first things that you hear sort of anchor your thoughts. So the first things you hear, it's sort of hard to combat information that comes after that. You also tend to, because we have a lot of information to process, we want to use simple heuristics. So we try to simplify our world by going along with simplified ways of seeing things. So think about, for example, when you're at a restaurant and you come in with a group of people who are similar to you in appearance, right? The maitre d' assumes that all of you are together, right? Think about the opposite if you come in with people who are different from you and they assume that you're not together. So these kinds of things happen in our everyday lives. We also tend to respond to the familiar. So we sort of are drawn to people who seem to be more like us, and we sort of create these in-groups and out-groups because it's easier to categorize people. We also tend to confirm information that we already know. So think about the fact that when it comes to social media, people tend to listen to social media stations that confirm their beliefs that already exist. They don't tend to listen to the wide variety of perspectives. So it's much easier to assume that other people agree with me if I'm only listening to the same message again and again. We also tend to make the mistake. Think about the fact that a lot of times when we make an error, we can blame the situation because we understand the situational factors that influence our behavior. With other people, we tend to point to their personality, and we don't show them the same kind of mercy we often give ourselves. Now, so we can think about these kind of cognitive biases and perceptual biases, but we also need to be much clear that our society is also framed a certain way. So think about the way we frame our society in terms of race. We use white racial norms to judge people of color. And when they don't conform to those standards, we don't see them in the same light. It's the same kind of thing when we think about the way society frames women. So for example, men leaders are seen as taking control. Women who use more collaborative kinds of ways of leading are seen as weak. So these things play out in terms of all the statuses that we value. So society tends to look towards whiteness, tends to look towards heteronormativity, tends to look towards males as the standard. And when people don't conform to these norms or conform to these standards, they're seen as less than rather than different. And so we need to be much more aware of how these things sort of process. The other thing that's happened over time is that racism used to be and racism, sexism used to be in our face all the time. So it's easy to identify. These things have become so embedded in our institutions that they're hard to identify. So a lot of times that we miss them, we don't recognize. So we have to be much more cognizant of how these things are embedded in our systems and how they're affecting our worldview. So I think, when we're thinking about the court system, we have to think about biases all along the way when decisions are made by all the participants, whether it's the litigants, whether it's the lawyers, whether it's the judges. We have to be much more cognizant of how decisions are made and get framed in all these situations. The other thing is that, and we're going to talk a little bit later, we have to think carefully about our assessment tools, how we assess and try to understand what's going on. Because again, our assessment tools have bias because they were built upon or made for certain groups and may be misapplied. So, one of the things I think is much that we need to be aware of is we need to stop and reflect on how biases play a role. And as our speaker spoke this morning, ongoing education is really key, both in terms of really understanding our own biases, but also understanding how these biases play out throughout our system.
Thank you. And yes, we will pivot our conversation a little later to talk about action steps and solutions. So now let's turn to talking about identifying bias in the system and how not only individuals, but who come to court to seek relief, judges, lawyers, practitioners. So what are the expectations for behavior, as alluded to by Dr. Springer? And, is the manifestation of trauma acceptable? Jacqueline, in your experience, how do you see judges address the issue in court? And how does the system respond to abuse?
Our courts overburden both victims and survivors with providing evidence and proof of abuse. And then they make you the guilty party, which is just weird and ridiculous. And, beating someone is assault. Raping someone is a crime. But if it is your own father or your mother who does this within family court, you get unsupervised access. And the parent who is desperately trying to protect the child is the problematic one. And that has to change. If this was a school bus driver and we had the evidence and the proof, that person would never be driving a bus again. They would be charged. But that's not what happens in family court. And we've heard the messages to leave abusive relationships, to get out, and we're overwhelmed by them. But we're not told what happens once we do leave. And we have a child with our abuser, because the abuse does not end. It gets worse once you enter our family court system. Our court system is set up to enable the abuser and dismiss the victim or survivor. And that has to change. And, I want to share some of the things that were told to me during Kira's custody case and told to so many victims and survivors in New York Family Court. The first one was, well, you chose to have a child with him. I never chose to have a child with Monster. I was also told, well, just because he abused you doesn't mean he will abuse the child. Well, I already see the eyes rolling here, and if your eyes aren't rolling, they should. I was told things that you're vindictive and scorned. Every fiber of my DNA was screaming to protect Kira from her abusive, murderous father. And that's how you get labeled. If you're not in, another thought process for the court is that if you're not in IDV court, there's no domestic violence. Trying to even get to that type of court is so hard for so many victims and survivors. This wasn't said to me, but I hear it from so many other parents. You're just in it for the money. And that couldn't be farther from the truth. We're trying to protect our children. And I have a very active student advocacy community at Kira's Champions. And they get told, well, you're being coached. The problem is not that they're being coached. It's a problem that adults are not listening when they speak up. And you'd think that some of these thoughts would end when your child is murdered. After Kira's murder, I went to many trainings to learn, to understand, to be an advocate. And at one of these trainings, I encountered a family court judge. And her response after hearing Kira's story was, to me, you're young, you can have another. Meaning I could have another child. Our court system, the Office of Court Administration, needs to learn our children are not replaceable. Period.
Dr. Springer, how does systemic bias influence the individual experience, and how are litigants perceived by the system, and what is the impact on them in their journey?
Sure. I think one of the things that we really see is that a couple of things go on. One is that we need to understand that people come with multiple identities, and it's the intersectionality sometimes that is even worse for clients. So think about the fact that if someone is low income, a minority, an immigrant, doesn't speak the language, that they're going to be perceived a certain way as opposed to someone who has more advanced statuses. And all these things play a role. I think one of the things that happens a lot is that people aren't aware of how these things are really affecting their perception of others. And we're colored by the society in which we grow up in. We're colored also by the media portrayals of different groups. And these stereotypes are in our mind. And I think we need to make them much more apparent so we understand how it's affecting how we see those who are in front of us. And I think it's important for us really to keep in mind that just as individuals are impacted by their environment, we're also impacted by our environment. A lot of times people get very resistant to recognizing bias because they say, oh, it means I'm biased, but we need to understand that we're all affected by the fact that we grew up in this society and that certain groups were viewed much more valued than others. And I think what is also tricky with systemic bias is that it's hard sometimes to recognize it. So what Linda was speaking about was all the invalidations that she and her clients experienced coming before the court. And it was very easy for people to minimize in some ways some of the things that she was experiencing because people again don't necessarily recognize how these what we call microaggressions really have a macro impact. They take its toll on the individual and the client. So when her client decided that she gave up, she didn't want to take this kind of treatment anymore, that was a loss. So we need to understand that these things have real vivid impacts for individuals. And we can talk about bias from an intellectual point of view, but we really need to understand the repercussions in terms of the kind of policies we make, the way we treat people, and we really need to intervene and offset these things.
Thank you. And now, Linda, now that we better understand how bias presents, how do you, as a practitioner, as an attorney for your clients, prepare your client for court, considering the systemic bias that they may be facing?
So we actually start having conversations with our clients very early on about what it means to engage with family or Supreme Court and just systems in general, and about the impact that it may have. And we start even with our helpline callers, where we ask very specific questions about what it is that they have experienced, what it is that they need, what are they looking for. And it's really important that we understand from the client's perspective what outcome they believe is best for them, and have conversations around whether or not the system they want to engage with is going to result in that outcome. And many times it's not. We represent clients from all over the world. And so we need to ensure that we understand any specific culturally forms of violence that they have experienced, because it may not be so evident to the court that what they experience is violence. And we explain to the client that part of the representation may be educating the court about their experiences and why what they experience is violence, and why it's detrimental to not only our clients, but their children as well. It's really hard to have these conversations with clients, because basically you're telling them that what they're seeking, which is justice and equality and fairness, is not what they're going to get. But at the same time, we do want to offer and avail ourselves of the systems that are protective of our clients. Orders of protection are a valuable tool in keeping our clients safe. And so it's really a balancing act to educate our clients about what they're going to emotionally and psychologically experience, while they get the legal remedies that can be life-saving to themselves and their children. And it's really about having conversations honest conversations, open conversations very early on. We have conversations about whether or not family court or Supreme Court is where they should be. And ultimately, provide the options and the information that the client needs for them to make a decision that's right for them. We have the hard conversation about access to non-custodial parents, which is one of the most devastating things that our clients hear every time they call. Because for them, it's very basic. If this person is abusive to me and my children, or my children have lived in a home where they have been terrorized and they're afraid, how is that parent going to have access to my children without some kind of intervention? And it is really the hardest pill for them to swallow. And we have to gently and carefully explain the system that currently exists, the way we're trying to change the system, but still empower them to understand that parts of the system can be helpful and beneficial. We explain that cases can go on for years, literally years, that a trial could mean you testify for 1 hour one day, and then you don't testify again for months. We have really honest conversations about the double standards mothers face. You're expected to be this kind of a mother. You're expected to have performed these kinds of services on behalf of your children. He's not expected to have done so much. And more importantly, we really try to help them feel empowered. And I really have seen the differences in the dozens of clients, if not hundreds of clients I've represented, from the day they call us, to the day they testify, to the day they walk out with custody or an order of protection, or an agreement that really takes into consideration their safety and their children's safety. It is really an incredible transformation. So there is a way that you can empower your clients, and that the journey, because it is a journey. I often struggle with using the word survivor when we talk about our clients. And I remember having this conversation with Dorchin, where when someone calls our helpline and they just describe being beaten, they're not a survivor, they're a victim. At some point, they hopefully become a survivor when they feel empowered enough to avail themselves of the remedies, or the systems have empowered them by acknowledging the harm that they've suffered. And our goal is always to help them through that journey, and to help them avail themselves of the systems of, the work that we've done from the day I started to ensure that the systems are more responsive and are more protective. And then we also explain to them that the fight is not ended. We are still fighting for systemic change every single day, and that their story is important and impacts the court, and hopefully will make it easier for someone else who comes in before that same judge with the same story after them.
Thank you. That is such an important point. And speaking of bias, that even with the best of intentions, by seemingly wanting to empower your client by calling them a survivor, is maybe silencing how they identify themselves, and allowing that space is really important to pause and reflect. Thank you. And building off of those best practices, Shane, specifically with transgender clients, how do you prepare them for a system that, as you said earlier, is already biased against them?
Yeah, that's a great question. So part of it is the office structure itself, right? What forms of identification are needed to even get back into the room to see me, so to speak? What does the space look like that I'm meeting with a client in addition to the usual best practices about, sit wherever you'd like to sit? Is it okay if I close the door? Thinking about what you can do to minimize difficulties that, I always like to say that I'm not always in the happiest area of law when I was actively practicing before taking over as executive director. And I just anticipated that I would have a lot of people crying in my office. So I would have particularly transgender women come in and their faces were, you know, beautiful makeup. And then we get halfway into the conversation and now there are the mascara tears running down their face. So thinking about what can I do to alleviate that burden of having to use a public restroom looking like that and go back out into the world. So I kind of just started as a practice keeping individual makeup wipes in my desk and makeup samples in my desk. So in a mirror over the file cabinet that had been wallpapered to look like a dresser. So it was just more of a home atmosphere that you were sitting down, having a conversation with me that could be very difficult at times, but take whatever you need, put yourself back together before you have to go back out there and fight into the real world. So part of it is, you know, the interactions to build up strength and camaraderie before you even set foot into the courthouse. And then the advocacy continues there on. We heard from the first panel about how something as simple as pronouns still continues to be an ongoing battle to make sure that litigants feel respected regardless of what the outcome is in their particular case.
Learning such great tips that you wouldn't have thought of. Thank you. So now we want to shift a little bit to talk about the other players in this system, specifically forensic evaluators. And we'll start out by hearing from Dr. Springer about the role or the impact that they can have in family court proceedings from Dr. Springer, and then would invite the panelists to speak to their thoughts and experiences so that we can address that issue. Dr. Springer?
Sure. So a lot of times when it comes, especially when you're trying to decide placement of children, forensic evaluators are called on to be an expert in terms of really trying to assess what's best for the family. And so theoretically, when you think about it, they need to talk to all members of the family and really get perspectives. They need to also talk to outside folks. So it could be things like speaking to educators, speaking to doctors, and so forth. What gets tricky, though, when you're doing a forensic evaluation is, are you using the appropriate tools? So again, you know, biases play a role here, is that people tend to use tools they're familiar with. Sometimes the tools that might be most appropriate are not available, because when you're dealing with people who from a different cultural background or speak a different language, again, trying to translate tools and making sure that people understand, even people's familiarity with being questioned can be quite different. So even then you're getting some biases introduced in the way you're trying to assess. The other thing that can unfortunately can happen is that sometimes the abuser can be the most charming person, personality wise. And again, you know, people can be fooled by someone who presents a particular stance. So again, it gets tricky when forensic evaluators are trying to assess. The other thing that forensic evaluators may not face is that there's no standardization currently in terms of people might be using different tools, different ways of interpreting, and so forth. And I think our reports need to be a lot more transparent in terms so that people can really understand what tools were chosen, why decisions were made, and so forth, and who was interviewed, and so forth. And we really need a more comprehensive kind of evaluation. What gets tricky sometimes also is that evaluators turn in the reports, but they don't get to speak in court. So again, you're seeing a written report, but really what was it that was assessed and how it was assessed can get kind of mired in the mud.
So I'd love to hear from any other individual experiences, whether as a practitioner or from personal experiences about an experience with a forensic evaluator. How did it impact your case and your client's journey?
Well, Kira's case, by the way, had 3 forensic evaluators in her case, one of which did the ultimate report. And to take a step back here, forensic evaluators, these are the wild, wild west. Like Carolyn was just mentioning, there's no standards, there's no requirements, there's no accountability, there's no way to remove bad evaluators from the system. So they just remain there. There was a case on Long Island with a 6-year-old boy who was sexually assaulted. The evaluator interviewed him on the bed where the assault took place. There was a case in Manhattan, another sexual abuse case with a child. The evaluator knocked, in this case, the mom, because she was drinking iced coffee during winter, and said that she had poor mental acuity because she was drinking iced coffee during winter. There's a sexual case, another sexual abuse case up in the Schenectady, Albany area, where the forensic evaluator forced the little girl to sit on her father's lap during the evaluation. And if she answered a question the way in which the evaluator wanted her to, she got a toy. There are vast reforms that need to occur within the space of forensic evaluators. Carolyn, myself, Jennifer Friedman, Joan Gearhart, who's here, and some of the other panelists who were speaking, we all sat on the Blue Ribbon Commission that the governor released a report in early January that has a series of stellar recommendations that need to be enacted in law to revitalize and vastly reform this space if we're going to continue with it. And if not, we need to place a moratorium on it or eliminate it completely, because they are so horrific. This has resulted in child murders like my own daughter and far too many others. And they're not doing what they're intended to do. And that is a true problem.
Linda or Shane, do you want to talk a little bit about any experiences or perhaps things that you'd like to see as a reform for some of these issues?
I mean, I think that one of the biggest issue with forensics is that judges rely too heavily sometimes on them and make custody determinations or force settlements based on what is documented in the forensic report, when the forensic report is supposed to be just one of the many factors that the judge should be considering in determining custody of the child, and not be the determinative factor. And it's almost what happens when there's over-reliance on the representations of the AFC as well. There's an over-reliance on forensic reports, and it's almost as if the forensic report is the determining factor in many cases when it shouldn't be. Many times the evaluators are not even testifying in court. I mean, it doesn't even get to that point where there's a trial and where they're testifying. And the validity of the report is rarely really examined in a way that really should be. And so what we find is that forensic evaluators who themselves are biased and write very biased reports, those reports end up being detrimental to victims of gender-based violence, who are not always going to present well under these forensic evaluations. And so they can have really devastating impacts on the cases of our clients and of gender-based violence survivors who are appearing before the court. And that definitely is something that has to stop. The judges have to be held more accountable when they over-rely on forensic evaluations in making custody determinations.
And on that note, I think we can shift into more of the action-based solutions. What can we do about this these problems? This morning, judges spoke to efforts for ongoing training, enhanced training. I think there are some of us who question sometimes the effectiveness of that, or how has that worked or not worked. What needs to change in the realm of training, and for whom, and how often? And then I think the corollary, accountability.
So I'd be happy to kick off that conversation, because this, I think, overlaps with the forensic evaluators as well, is making sure that all of the parties in the system really understand the difference between sexual orientation, gender identity, and gender expression. There is still a misconception that the person in the relationship who presents in a more feminine way is automatically the victim as opposed to the abuser. And we know that that's not always the case. So I think that's a critical piece of training, is making sure that those three concepts are really understood from as a baseline.
Absolutely.
And I think training really needs to be ongoing, and it needs to be for all parties. I think one of the things that we really find that if you really do make the visible invisible. So when it comes to things like really understanding how domestic violence plays out, if we really understand how implicit bias works. And I'm also going to make a push for really understanding how people respond to trauma. Because one of the things that we see is that a lot of times people's affect is not what you would expect. And they get judged because their affect is not what, it doesn't fit the norm that we would expect. But a lot of times what happens to people who have been traumatized is that they have flat affect. So they don't respond the way that you would expect. And I think those kinds of trainings where we really think about when someone has been traumatized for years, how are they going to present in court? I think it's important for us to understand that. And I think it's important for us to have the ongoing training on domestic violence and really understand how interpersonal violence plays out, how conflict is negotiated in families. So, and I think really, it really means ongoing, because things, as we get more and more research and more evidence, we need to bring people up to speed. So it can't be a one-stop kind of deal. It needs to be ongoing.
You know, it's interesting that we use the word culture a lot to describe what happens in the workplace, but we really don't use it to describe what happens in the court system. And there's a culture. There's a culture of oppression, discrimination, racism, and sexism. And all the training in the world is not going to change that.
Mm-hmm.
And that's, I think, one of the biggest problems that really isn't being addressed is what is the culture in the court system? Mm-hmm. And usually it's that the litigants and the attorneys are the others, and they're seen in a certain light, and the litigants are seen unfavorably usually. And if you're a woman of color, you're seen even more unfavorably. And I don't know that training is going to change that. But what I do believe is going to change that is accountability. Mm-hmm. Because that is what's severely lacking in the court system. And what we've talked about is creating a portal for litigants, for survivors, where they can go and find out what are the appropriate redress that they have when something that they've experienced in family court has been oppressive, racist, sexist, classes, or even just contrary to the law, which it might be surprising, but we see a lot of lawlessness in family court. And there's nowhere that you can go to address that. Usually, if you're fortunate enough to be connected to someone who's connected to someone, you can sort of find a way around it. But if you're a litigant or you're a solo practitioner and you're having these experiences in family court, there's really not a whole lot you can do. Also, when this court has the power to take custody away from your client or deny your client an order of protection, you have to tread carefully. And many times you have to wait until the end of the case where you're given a decisional order that you can hopefully appeal if you have the resources, if you can get a pro bono to help you, or if there's some way that there's an appealable part of that decision, because oftentimes what happens is not on the record or is not written in the body of decision, but it's happened nevertheless. Many things that have happened off the record. Many times I've been called back to chambers where that's where the racist, sexist, classist comments really come out. And then you go back on the record and you would never know it happened except if you were in the room. So really what we need is accountability. And that's really where the focus needs to be. Because what's always been really interesting to me is that when you read about how judges and jurors are supposed to behave, it is a really high standard. I mean, it is really high. You're supposed to be ethical and impartial, and you're supposed to rule in a certain way. But when you're in court, you wonder, where is it? Because it's not happening here. And if you're held to this standard and you're not doing what you're supposed to, what you swore to do, what happens to you? And what we find is nothing. So until there is accountability, we're not going to see real change. And while the training may impact those who are willing and are receptive to be changed, because remember, all the training in the world is not going to change you if you don't think there's anything wrong with the way you think and the way you believe and the way you rule. But if you may be taken off the bench, or if there's really going to be real ramifications to your behavior, and then there's going to be a cultural change, that's when real change is going to begin.
I want to pick up, Linda, on exactly what you're talking about. First, I want to highlight something with training. I personally went to so many different trainings all around New York State and even in other states after Kira's murder to learn more. And I can count on one hand the number of good trainings that I attended. With training, we need to make sure we're identifying the right actors to do the training. That is so critical and so important. Bad training is worse than no training. Now, what Linda's also talking about here is accountability, and this is something that is so important. And right now in New York State, I have 8 bills that are inspired by Kira's custody case to better protect children, one of which is Kira's Law. And Kira's Law, by the way, is common sense legislation. It does really 3 critical things. First thing is to make the child's life and safety the top priority in a custody case. This is common sense, but it's not happening in reality. The second thing is judicial training. And again, identifying the right actors to do this training. And third, it stops common practices that allow abusers to gain custody. But one of the other critical things that we brought into Kira's Law, Linda, just like you were talking about, is accountability. Because you're right, until the judge renders a decision, there's no amount of accountability brought into these cases. And that's a huge, huge problem. What Kira's Law will allow us to do is early on in the case, you can have an emergency hearing to protect the child, which forces the judge to render a decision, which would be appealable. And so for the first time, we can get accountability, judicial accountability into this system, which is so desperately needed and so critical. And that can have such a huge impact to all of us.
And keeping with the accountability piece, as either a litigant or as a lawyer, at the time that you experience the macro or microaggression, you make that very difficult decision of, do I risk the future of this case by raising the issue now? Do I try to get it on record, flagging that I'm going to raise it on appeal? Do I not say anything? And just from seeing the faces and the nodding heads, I think, it's the negative data, so to speak, that of all of those instances that even in this room or the people watching have experienced and chose not to, because you're thinking of the interest of the client, the future of the case. How do we balance that? Maybe it is getting that decision on record earlier. How do you hold accountability on the course during the case? And how do you balance the interests of the client and your own need to make change and change the culture?
It's interesting because I have these conversations a lot with the attorneys that we work with. And it's always a balancing act, and it's always reading the room. And it changes from appearance to appearance at times as well. And you're always thinking about, okay, it's about creating a record, right? You have to see the bigger picture when you're litigating a case. You have to see, when I first speak with a client, I'm already thinking about trial. And I'm already thinking about that's just the way lawyers are trained to think. And so when I'm litigating a case, when I'm in court, I'm thinking about creating that record. I'm thinking about ensuring that this is documented. It might not be helpful now. It might not be helpful at the next court date, but at some point, that record can be helpful. And when I've experienced microaggressions and racism behind the closed doors and chambers, off the record, when we go back on the record, I put it on the record. Now, what you have to be comfortable with when you're a litigator in family and Supreme Court is not being liked. Because oftentimes judges are not going to like what you're doing because they get it. They get what you're doing. They get you're going to appeal the case or that you're creating a record for a particular reason. But it's your job to protect your client and to do everything that you can to put them in the best possible light in the event that there's an unfavorable ruling. And the record is the only thing that's going to survive the case, that's going to go up to the appellate division or the Court of Appeals. So you have to make sure that you preserve that record, whether it's going to upset the judge or not. You also have to think about what impact your decisions are going to have on your client's case, because ultimately your client is the one who's going to bear the brunt of whatever wrath the judge may have by a decision that may be unfavorable. And so you have to learn the skill of diplomatically arguing a very zealous case. And my children always say that they cannot believe how calmly I can tell them off. And it's a skill that you learn, right? Well, with all due respect to the court, this is contrary to the law, Your Honor. And sometimes you have out-of-body experiences. Like, I literally have been in court and have left my body when judges have said things that are so racist, or when an opposing party is screaming at me and yelling at me and berating my client, and the judge is letting it go on. And then you come back into your body, right? And you compose yourself and you go forward. And you have to have a tough skin to do this. But if not us, then who? Like, who is going to be there on behalf of the litigants who need representation and who deserve the representation because they are the most marginalized, the most oppressed, and the most victimized? And it's hard, but you have to do it. So we really think carefully, and you have to wear so many different hats, and you have to be so fluid in how you approach the case and in how you approach the court. But you really have to think strategically and think about the end goal, which is getting your client to the relief that they need.
Thank you. I'm aware of you and all of the other experienced litigators in the room for whom it took years to do that, to learn how to come out of your body, do that, and then come back. And the newer attorneys who are thinking, how do I become you? How do I do this? And how we have to bring it back into our organizations, to our firms, how we need to talk about it. I mean, we're trained to advance in our careers based on a certain set of unwritten rules, which is to be liked and not make too many waves, but enough to get noticed. And it's really contrary to a lot of what the bias that Dr. Stringer was talking to as well of, contrary data or that. But it is creating a space where you can talk about this, how hard it is, and not necessarily giving an answer or having the answer, but really talking about how you've had to do that. And you're sharing these experiences, I think, is a great step in that direction.
Yeah, I also think that it's really important that organizations have a process in place for the staff to be able to know what to do, what happens when they've had these experiences, because they need to be able to look towards someone in their organization, one, to just validate what they've felt. Because one of the things that, when you're a person of color, when you're a woman, you're so used to this. It's been so ingrained that sometimes you just internalize it. Mm-hmm. You come back to the office, you get back to work, And you just don't realize how it's impacted you. But it has impacted you. You are forever changed after you have these experiences. And it's really important that you take the time and that your organization creates the space for you to be able to come back and say, you know, I just came back from court and this judge said this, or this attorney said that, or I had this experience. And someone say to you, wow, that's really horrible. Like, that's wrong. That's racist. That's you shouldn't be having those experiences. Or that we can come and say, you know, this judge just said this to me. And that someone is going to say, you know what, I'm going to pick up the phone, or this is the grievance process that we follow. Let's sit through it. Let's go through it together. We need to support staff who are doing this work, because one of the saddest things for me is when, you know, in about 1998, 1999, I started an uncontested divorce project where I trained law school students. And I ended up working with 6 different law schools in New York City. And I would carry the files of my monolingual Spanish-speaking clients from law school to law school to law school because I couldn't place them. Not much has changed. And that is a travesty, that we do not have more people of color in the profession. And when you look at working with gender-based violence, we're working with a very specific area of law. So to have an attorney of color willing to do not-for-profit, willing to do gender-based violence, like, that's already narrowing the playing field. But when you don't even have a pool of law school students to recruit who are part of these communities, it is a tremendous loss, not only to the profession, but for the litigants that want to see an attorney that looks like them, speaks their language, and understands what it's like to become from an impoverished background, because that's really important. And we're not seeing that. And so if we don't set up the system, you know, from early on, have better education for middle school kids, high schoolers to get into college, to become lawyers, to be able to come into this field and support them, it just creates a greater injustice for the litigants that need their representation. So as leaders of organizations, we need to make sure that those who are willing to do this work and are in the trenches and are fighting every day, that we support them in the best way possible. And that is with pay, because we know that getting attorneys to work at not-for-profits at the salaries that not-for-profits pay is one of the hardest things to do, especially with the enormous student loan debt that they have. So we need to find a way of paying not-for-profit attorneys better. We need to do something to help with student loans. And we need to support the attorneys that are there, because if they leave, there are not going to be a lot of attorneys that they're going to be able to be replaced with.
Absolutely. I mean, I will say Her Justice and probably several other organizations here are looking to hire a bilingual attorney, and it's been very hard. And that speaks to what you just explained. And we need that. We need that to reflect the needs and identities of our clients. What other, we have a few more minutes before we open it for question and answer. What other opportunities or fixes, maybe legislative fixes, as you spoke to earlier, do you see that is it a legislative fix? What are some other solutions or action steps that we can take and support?
In terms of fixing and transforming family court in New York State, it boils down to legislative action or executive action. It is not going to come from the Office of Court Administration. And, you know, when I first went to Albany and knocked on the first door to start bringing about legislative changes, from where we were a few years ago to where we are today are vastly different stories. When I first walked into Albany, people weren't sure if I was actually speaking the truth of what's happening in family court, about how bad it is. Now that has dramatically changed, because quite frankly, I'm wearing sneakers today, and that's going to probably be the way that I am until we actually pass all of these bills. because I pounded my, on the pavement to knock on every door so that people would start to understand the dynamics and how badly children are being treated in our family court system. But if we want to have change happen, it is going to be on that front. OCA has had decades to make changes here, and they've failed time and time again. So it's going to be on these fronts. And like I said, we have 8 incredible bills. And if anyone wants to get involved, by the way, the easy way to do this is if you go to curaslaw.com, in 10 seconds, 20 if you're a slow typer, you can put in your snail mail address and you can send a letter to your legislators. And also, this way I get to contact you and say, be part of our team. We need you in Albany communicating this to legislators to bring about the changes for a better tomorrow.
Yeah, and I think there's certainly an opportunity for bar associations to step up and be more involved in this arena, some of which Linda already alluded to in terms of building out the pipeline that many of the affinity bar associations are already doing a job of. I'm not going to say a perfect job because there's always room for improvement, but they are in that space. It's a starting point. So if the bar associations could be putting a brighter spotlight on a lot of these issues, I think it would carry a lot of professional weight.
Absolutely. And I think to the point of collaboration, as Linda was saying, bringing it back to our organizations, but the coalitions such as the Roundtable that organized this, hopefully will live on beyond this conference as another space where we can share these stories and strategies and efforts to identify and move forward some of these action items. Great. So I think we're just about at time for question and answer, but a CLE commercial note for the code for people who are watching remotely. Please note that the CLE passcode is 4E6UHM as in Mary. Again, that's 4E6UHM. So, yep, do we have some questions in the pipeline? Wonderful. And Rachel Bronstein, Director of Policy at Her Justice, is our question reader.
Some of these great questions have been addressed by the panel, but some are wonderful additions, I think. One is, and maybe Dr. Stringer, you can take this one, is as to the efficacy of training, are there ways to know if training works? Are there measurements or evaluations to say this has been effective or not?
Yes, there are assessments for evaluating some of the trainings for example, for implicit bias. And again, you also want to vet the people who are doing the training. And I think actually having a collaboration between social scientists and lawyers and judges, I think would work, because partly it's to understand the research, but also to understand the environment in which you're trying to train for. So yeah, but they are assessments.
And as to the topic of accountability, one question came up about greater either publishing of or publicization of family court decisions as a way to increase transparency and therefore accountability. I don't know if anyone wants to speak to that.
And maybe repeat the question just so I'm not sure if they can hear.
So the question came up as to greater publishing of family court opinions or publicization, in the news, media, so forth, of family court opinions as a way to increase transparency and therefore accountability of family court decisions.
I mean, I think with the backlog in family court, I wonder how feasible that is. But because a lot of the things that happen in family court, as I said, are really not reflected in the decision, I have to think about that. I mean, I guess it's possible if I really have to think about that one. Yeah, Kim, thank you.
I think that's actually a really good point. And I would do a few things if you get a decision. One is to immediately send it to the law journal with a letter accompanying it, saying why it's important that this get published. Then I love your idea about the Bar Association. You could send it to the Bar Association. They can publish it in their newsletters. Or do a press release from your agency. I think there's several ways to advocate. A lot of times the law journal just doesn't pick it up. And a lot of times the judges don't send it to the law journal, so you have to.
As you're talking about, and it's on this topic, but a little bit off about transparency and accountability. When it comes to judges, who's actually on the bench? We heard this a little bit from the previous panel, but in Nassau County, for example, in the last election and in this election as well, there were 8 open seats for Supreme Court. Well, the Democratic and Republican Party only nominated 8 candidates for their judicial quote unquote election. Those aren't elections, those are appointments. We need to make sure that our judges, who are they? If we're electing our judges, we should know about them. Was there a homicide in that judge's courtroom? Things like this, we should know when we're going to and voting for them at the polls. In 14 counties in New York State, in the last judicial election, there was no election. There were appointees, and that needs to change.
I think just on the point of transparency and information about cases, about the courts, about judges, sharing data, we've recognized that the courts are under-resourced, but there's definitely information that they can and do track that would help us collectively be able to say how many of these complaints have been, what happened to them after the complaint was raised. And I think that would also help inform different strategies about where we need to place our efforts.
Yeah, and just to lift up that point, because it was also in a question or a comment, the need for, and I'm going to sort of ad lib here, but the need for other ways to surface this information. I mean, this is a room full of folks who are committed to these issues and the folks on the Zoom. What are other ways to sort of tell this story in terms of surfacing data, in terms of watching the courts, in terms of bringing up complaints? And so just to sort of make that point here, a commitment to describing the problems so that solutions can be brainstormed by folks like all of us. And to that end, a question came up about the issue of inconsistency between judges, even those sitting in the same courthouse, and how folks might think to raise up that kind of an issue, that there's a lack of uniformity.
I mean, I think that goes to the accountability issue, right? That it's like who's really watching what's happening in family court. Years ago, decades ago, I think even, we had a court watch project where we had law school students sit in the courtrooms, and we created this form where they would sort of check off what was happening in the courtrooms. And we had all these, I think I may still even have them, all these different forms, and we got stuck at getting a statistician to the reporting part of it. But it did have an impact when the judges knew that there was someone watching. And so, like, who's watching? And what are they watching for? Because they're not watching for what we're talking about in this room, and that's the problem.
I think, Dr. Stringer, you said some, I thought, really valuable words about making the invisible visible. And Her Justice did a Court Watch project a couple of years ago, and it was, I think, really impactful for the point that we're saying here, just being in the courtroom, knowing you're being watched. There's a question about, and I think, Linda, you spoke to this, but there's a question about, and I loved how you talked about support for staff, but when agencies are hearing from staff that their lawyers or clients are experiencing bias in the courts, are there ideas for how agencies could relay that to the court system itself?
I mean, I think we do so in committees. the Lawyers Committee is one committee where many organizations meet and really talk about what's happening in the court system. NISCADIV is another place where there's conversations and there's action around what's happening in the court. But really, it has to be more than these organizations, you know, for it to sort of get reported, and what gets reported and how does it get reported, instead of the court system like fixing itself.
I think the challenge sometimes is also judges are given, and to some extent, it's understandable, discretion on how they run their courts, judges, referees, and who holds them accountable, to the point of, if it is OCA, where does that need to come from? And is it putting too much burden on the people who've been marginalized and oppressed and impacted?
And again, to the sort of system point of the court system versus legislators, I understand, Shane, if you would be willing to speak about some legislation, anti-discrimination legislation that, I don't know if it's been introduced, or would you tell us about it?
Sure, I'm happy to speak about that. So some of you in the room might be familiar with GENDA, which added gender expression and gender identity, including transgender status, to the New York State human rights law as recently as 2019. Prior to that, sexual orientation was explicitly articulated, but those other categories were not. So one potential legislative fix would be thinking about, fortunately, unfortunately, removing some of the family court's discretion and thinking about, when they are making a determination for the best interest of the child, that the court shall not consider the sex, sexual orientation, gender identity, or gender expression of the parties, or prohibit a party from undergoing gender confirmation, surgery, medical transition, legal transition, social transition, whatever those components may look like. So there are potential legislative, I don't want to say fixes because nothing is perfect, but improvements, hopefully, that could be made. But unfortunately, this bill did not get a lot of traction this particular legislative session. Hopefully in the years to come.
And I understand it's in the materials on the HOVA app. Is that right? I think so.
Yes, it is.
Wonderful. Okay. Let's see. Do I have? I guess one other. We're going between the huge and then the drill down. But one other sort of drill down question is, if I guess the litigators on the panel or others have thoughts about how to challenge a biased forensic report in a particular case.
You have to get the evaluator on the stand and do one hell of a job on cross.
And have you had that experience?
I had the wonderful experience of the judge saying that they were not going to be considering the forensic evaluation because of the evaluator not even being trained in domestic violence. And that was a glorious day.
Sounds like it. Congrats.
I'd like to jump on that one too. I had a horrible forensic report in Kira's case. And, this just goes to so much of what's so wrong with forensic evaluations in New York State. Again, this is the wild, wild west. And that if we're going to keep these need vast reforms. First of all, we should have an immediate moratorium on these right away and implement the changes that were put into the Blue Ribbon Commission. And if we're going to continue with them, if not, eliminate them completely. The amount of bias that goes into these and how detrimental these are to children in custody cases is astounding. And the costs associated with these are mind-boggling. In the New York City area, it's not unheard for these evaluations to go $50,000 or more. Now, if you have a bad evaluation, you then have to hire someone to peer review it at an additional cost. And you have to pay that first evaluator to go on the stand, plus another one to peer review it, and for them to go on the stand. The costs with trying to protect your child from an abuser in a custody case are astronomical. And it should not be this much to protect a child.
I have one more question here, and I also have a request, and I would love for the person who put this in to say more if they would like, but to plug the Inspector General's office for the place to make complaints about judicial bias. Does anyone want to speak to this on the panel or otherwise? Experience or tips? Okay. I think it maybe came from the Zoom room, but know that the Inspector General's office will accept complaints. So I'm going to ask, do you want me to ask one more question or no, Jennifer? Save it.
We do have a few announcements.
Okay,
and
please.
So I think we can thank our panel so much. So thank you, everyone. I know it's a long morning and going to be an even longer afternoon, but I hope people are feeling inspired and excited and energized. I do have a couple quick announcements. First of all, so many of the materials that accompany this are in our HOVA site under each, I don't know if people are seeing, it's the CLE materials, the legislation that Shane mentioned. Actually, quite a few I found really, I had to read all the materials. They're really excellent. And Dr. Springer's materials regarding how bias functions, I found very, very fascinating and interesting to read about all of the anchoring and all of the other things. So just, I encourage folks to take a look at those. The evaluations for the CLE are sitting on your table. Proskauer has really been generous in giving us their time of their CLE team, and they really do need the outcome of the valuation. So please do take a moment to fill those in. Your CLE forms are also on the table for those in the room. Please do not forget to fill them out so you get credit for being here. And those online, you have to email those in with those codes that have been getting read. I'm not sure if everyone physically in the room knows that there's a reception at the end of the day. Whenever it is that we end 4:30, 4:45, hosted again by Proskauer here with like food and beverages. And we hope folks will stay and enjoy that. And if you didn't RSVP, it's okay. They got extra food. So please join us. And I believe that's it, other than panel stay for a moment to get a picture taken. Okay. Thank you, everyone. It's lunchtime, but at 12:25. Please rejoin us for our, I think we're in for a treat with our lunchtime speaker, Stephanie McGraw. So look forward to seeing you then. Thanks.